Ever watch a movie where a will is read and they dramatically throw around the term executor? Or maybe you've heard trustee and power of attorney in family discussions and felt like you needed a law degree just to tell them apart. It can definitely feel like a lot of legal spaghetti with terms that sound similar but do wildly different things. One person has power while you're alive, another steps in only after you die, and a third might do both. Getting them mixed up isn't just confusing, it can cause real problems for the people you love. But here's the good news: you don't need to be legal to understand these roles. You're going to cut through the jargon and break down these three critical roles in simple everyday language. By the end of this, you'll not only know exactly who does what, and also feel more confident about the planning for your own future. Let's kick things off with the one role that's all about when you're alive and kicking: the power of attorney. A power of attorney, or POA, is a legal document where you, the principal, give someone you trust the power to make decisions for you. This power is only valid while you're living. Think of it like picking a trusted stand in for specific situations. This person can handle your finances, like paying your mortgage, filing your taxes, or managing investments, if you give them a financial POA. This is incredibly useful if you become ill, are traveling, or simply want someone to manage things on your behalf. Or they can make critical healthcare decisions if you're ever unable to, which is handled through a healthcare POA. This could involve consenting to medical treatments or choosing doctors, ensuring your health preferences are honored. Now, a crucial detail is making sure it's a durable power of attorney. A non-durable POA actually becomes invalid if you're incapacitated, which is often when you need it most. A durable POA, however, explicitly states that it remains in effect even if you can't make decisions for yourself, ensuring your chosen agent can step in seamlessly. But here's the most important thing to remember: the moment the principal passes away, the power of attorney document is no longer valid. Its authority ends with your life. Any jobs that need doing after death, that's for someone else to handle. This brings us to the executor. You've probably heard this term whenever last will and testament is involved. An executor is the person or institution you name in your will to be in charge of settling your estate after you die. Their power only kicks in after your death and only once a probate court gives them the official green light by issuing legal authority. While you're alive, your named executor has zero authority over your affairs. The executor's job is basically to be the official project manager for wrapping everything up. They're responsible for finding the will, taking it to court, and then gathering all of your assets and safeguarding them during the probate process. They also create a complete inventory of everything you owned. A huge part of their duty is to formally notify creditors and pay off all the final bills, debts, and taxes your estate owes, using the estate's funds to do so. This isn't a simple task. Executors can be held personally liable for mistakes, like failing to pay a tax bill before distributing money to heirs. Only after those financial obligations are settled can the executor distribute the remaining assets to the people you named in your will, known as the beneficiaries. This whole court supervised journey is called probate, and it's a public process, meaning the details of your will and assets can become public record. An executor's job is officially done when the court agrees all tasks are complete and closes the estate, which can take anywhere from a few months to several years. Finally, let's talk about trustee. A trustee's role is tied to a powerful estate planning tool called a trust. Think of a trust as a special container you create to hold your assets, like property, investments, and bank accounts. The trustee is the person or institution responsible for managing everything inside that container according to the rules you set. Unlike an executor who handles all assets in a will, a trustee only has control over assets that are actually titled in the name of the trust. Now here's the key difference. A trustee's power can start whenever the trust document says it should. It could be while you're alive, or it could be after you pass away. For instance, many people set up a trust and act as their own trustee. Initially, in that case, you also name a successor trustee who is primed to step in and take over if you become unable to manage things or after you're gone. The trustee has a significant legal responsibility called a fiduciary duty, which is the highest standard of care in the law. This means they must always act with loyalty and in the best interests of the trust beneficiaries, avoiding any conflicts of interest. Their main job is to manage and hand out the trust assets to the beneficiaries, all according to the detailed rulebook you wrote in the trust document. Unlike probate, trust administration is typically a private process, shielded from public view. This role can last for a very long time. For example, a trustee could manage funds for a child's education and well-being for decades, all depending on your instructions. So let's put these roles side by side to make it crystal clear. When are they in charge? A power of attorney is for when you're alive and becomes void upon your death. An executor steps in only after you die, and their authority is granted by the probate court. And a trustee? Their power is flexible. They can be in charge both during your life and after, all depending on how the trust is written. Second, what do they control? A power of attorney can be given broad authority to manage your personal and financial decisions during your lifetime. An executor manages all assets that are part of your probate estate, as laid out in your will. A trustee, on the other hand, only controls the assets that have been formally placed inside a trust. If an asset isn't in the trust can't touch it. Third, what gives them power? A power of attorney is created by a POA document you sign. An executor is nominated in a will and officially appointed by the court. And a trustee is named in a trust agreement, which is the legal document that creates the trust itself. And finally, let's consider court supervision. The agent under a POA acts without direct court oversight. The executor, however, works directly under the supervisions of the probate court, which publicly oversees the entire process. The trustee generally acts privately without court involvement, unless a dispute arises. The privacy and efficiency is a major reason people choose to use trust. Getting a handle on these roles is a huge first step in building an estate plan that truly protects you and your loved ones. These jobs aren't mutually exclusive, In fact, a great plan often uses all three, and you can even name the same trusted person for more than one role, if that makes sense for your situation. But it's vital to understand they are all separate hats to wear. The big takeaway is that these are distinct gigs with different start times, different playbooks, and different duties. The power of attorney is your in-life manager, your advocate for when you can't speak for yourself. The executor and trustee are your afterlife managers, one for your will and the public probate process, and one for your trust and the private administration of its assets. Creating a clear plan with these roles properly defined is one of the greatest gifts you can give your family, saving them from confusion and potential conflict during a difficult time. If this breakdown helped clear things up, feel free to give this video a like and think about subscribing for more simple takes on complex topics. And remember, everyone's situation is unique, so it's always a smart move to chat with a qualified legal professional to make sure your own plan is built just right for you and the people you trust.